Good afternoon, everyone. Rajesh ji, welcome. Manoj ji, welcome. Shall we start the session now?
या आई थिंक हम लोगों ने 5-7 मिनट वेट कर लिया तो विद द ऑब्जेक्टिव कि चलिए कुछ और लोग भी ज्वाइन कर लेंगे।
I think already 15 participants are there. I think some more will join.
7 मिनट सर, 15-7 हुए हैं सर,
15
बताइए। हाँ जी,
क्या है?
7 मिनट ऊपर हुए हैं, 7 मिनट ऊपर हुए हैं।
हाँ, right. Okay, let's start, huh?
हाँ
So,
जी।
first of all, on behalf of IPA, I welcome you all. And you are aware that we have been making efforts to see that whatever new developments are there relating to the profession, those are with respect to the same. We apprise our members, we do our knowledge sharing, and especially whatever judgments are there, landmark judgments are there. So we organize webinar so that members, they come to know as to what that judgment is, and then we invite some expert so that we can know the views of the expert. So I think Rajesh ji does not need any introduction. All of us are aware that Rajesh Sharma ji is former member NCLT. And I think before starting, let me, though all of us are aware, but in brief, will share his profile with you. So this is Rajesh Sharma ji is a former member NCLT, where his proficiency in insolvency and bankruptcy law is quite evident. All of us are aware that, and mostly we find him sharing his views in seminars, webinars, seminars, and all that. His bench at Mumbai disposed of more than 2,500 cases of IBC and Companies Act in a span of total 500 days sitting, thereby giving an average disposal rate of 5 cases per day. My God, 500 disposal must be a record. It's a big achievement on his part, and this must be one of the highest disposal rate among all NCLT benches across India. Recipient of most prestigious National Award of ICAI, CA Member in Public Service 2022. He is a fellow member of ICAI and an MBA Finance from the Faculty of Management Studies, University of Delhi, apart from the postgraduate in Commerce and so on. He has also held pivotal positions as the Chief General Manager at the NHAI, as the CFO of the HSIDC, and as Director General of the Services Export Promotion Council of India, Ministry of Commerce and Industry, Government of India. Over his 33 years career, he has excelled in various domains, including insolvency and bankruptcy law, NPA management, finance, economics, accountancy, industrial management, and corporate governance. He is a sought-after speaker at national and international conferences and has been actively involved in government and non-government committees and delegations. His extensive global experience is evident through his travels to various countries, enriching his perspective. He is one of the distinguished professionals in the country who is having end-to-end experience from the stage of conceptualization of projects to resolution or dissolution of the corporates. His YouTube channel, Insolvency Veterans, is quite popular. All of us must have seen, I think I'm regularly seeing that, sir. It is quite popular, where he discusses IBC and corporate law with luminaries like SC and HC judges, former president and members of NCLT and NCLAT, etc. So please join me in welcoming Rajesh Sharma ji. So,
Thank you.
So sir, welcome, and I think we will be having an interaction where after this event, all of us will be immensely benefited with your experience and knowledge. And before that, I request our President IPA, which is Mr. Manoj Anand. I think he will be just briefing us, and then after that we will be having a session. We will make discussions with Rajesh Sharma ji, and if we are having any questions with respect to this particular judgment, so we will be asking those questions with Rajesh ji, and we will request Rajesh ji also to tell us as to what is his view about this particular judgment and what is the ratio of this particular judgment. But before that, Manoj Anand ji will be briefing us about the facts and about this judgment. So over to you, Manoj ji.
थैंक यू वेरी मच, थैंक्स अ लॉट। हम लोगों ने बहुत ही शॉर्ट नोटिस पे शर्मा जी को, राजेश शर्मा जी को रिक्वेस्ट करी आज मॉर्निंग में, एंड ही वाज, आई एम रियली हैप्पी टू से दैट कि इन्होंने बीइंग आवर गाइड, फ्रेंड एंड फिलोसफर, और मोर एज ए फ्रेंड, इन्होंने हमारी रिक्वेस्ट को असीड करा और कहा कि मैं मनोज जी आपको अपनी ब्लेसिंग्स दूंगा ज्वाइन करके। और बेसिकली आज हमारा डिस्कशन का जो मुद्दा है सेक्शन 12A है। और इनफैक्ट व्हाट लिटिल बिट आई नो अबाउट हिम इज आल्सो कि जो ऑनरेबल सुप्रीम कोर्ट ने व्यू लिया है, देयर वाज अ क्वाइट कन्फ्लिक्टिंग व्यू ऑन दिस पर्टिकुलर सेक्शन, बट शर्मा सर का भी वही व्यू था जो अल्टीमेटली ऑनरेबल सुप्रीम कोर्ट ने लिया है, व्हेन ही वाज प्रिसाइडिंग एनसीएलटी बेंच there. So, Sharma ji, we are really, really thankful to you, and we welcome you wholeheartedly also. Mr. M. Kumar also promised to join us. So, but उनका all of a sudden कोई program आ गया. He will be joining us in between. He said कि for a brief I be joining there. तो we thought कि जब हमारे साथ दो such a big luminaries are there, तो मैं इनके सामने क्या कुछ बात करूंगा, कुछ कहूंगा. But even then, just to start with, Mr. Sharma, would you like to have some few words before we start deliberating on our this technical topic? Please say a few words.
Yes, first of all, Mr. Anand and Mr. Sharma, thank you very much for inviting me here. I was watching this case when Byju was being discussed in the Supreme Court. And, it is really heartening the way the Supreme Court has dealt with this case, because it has set all the ambiguities to rest. And now I think all NCLTs and Honorable NCLT, they all will be adhering to what is required in the law and what is being practiced. I think there will be a synergy in both the things, which was somehow lacking somewhere. It's a very new law that way. And I hope now everything will be streamlined. Yes, please.
Thank you very much. Thanks a lot. Thank you. Thank you. तो बेसिकली जो हमारा आज का सिस्टम है, इसके अंदर जो बेसिकली केस है, इसके ऊपर मैं ब्रीफिंग सारी की सारी दूंगा सब लोगों को। जो भी इसके अंदर ऑनरेबल सुप्रीम कोर्ट ने एडजुडिकेट करा है, इस केस के अंदर क्या की पॉइंट्स हैं, उन सब पॉइंट्स के ऊपर मैं अपनी जो भी केस लॉ से रिलेटेड था वो था, तो इसमें अप्रॉक्सीमेटली मैं हाफ एन आवर टाइम यूज करूंगा। और उसके बाद जो है हम लोग लास्ट के जो 15-20 मिनट, आधा घंटा है, उस पे सर से हम लोग इनकी जो यानी कि जो एनालिसिस है इस पर्टिकुलर केस के बारे में, जो व्हेन ही वाज अ मेंबर ऑफ एनसीईआरटी बेंच, तो किस किस तरह के इस पर्टिकुलर थिंग्स के ऊपर चीजें डेवलप हो रही थी, तो वी शैल लिसन टू दैट देयर. Okay, now let me start my formal presentation. Good afternoon, my esteemed colleagues and friends. As we gather today, I extend my forthright wishes for a prosperous and joyful Diwali. This auspicious occasion embodies renewal, resilience, and unity, values that are fundamental to our professional pursuits and collective success. In fact, after extension of last day of filing of returns today, I found accelerated webinar joining. In any case, in today's session, we shall delve deep into Section 12A of the IBC, read with CIRP Regulation 30 Regulation 2. As you are aware, that Section 12A deals with withdrawal of IBC cases and has played a significant role in numerous insolvency proceedings. With a notable, I repeat again, with a notable 43% of the cases either directly or indirectly influenced by these reasons. Although it is a very small section, but still it has a very big influence on sorry, some technical issue do creep in, and as a result of which I was speaking, I thought I'd been listened, but I was not being listened. Is that okay? Is my voice clear now?
Yes, yes.
Yeah, actually, I was just talking. I thought I'd been listened, but it was not, coming out to be. In any case, I start again. In today's session, we shall delve deep into 12A of the Insolvency and Bankruptcy Code, read with CIRP Regulation 30 subsection 2. As you may be aware, Section 12A deals with withdrawal of IBC cases and has played a very significant role in numerous insolvency proceedings, with a notable 43% of cases either directly or indirectly influenced by its prison. Please note, out of total 7,813 CIRP cases, 1,096 cases were directly settled under Section 12A, and 1,192 cases were settled under appeal review the prisons. This data I have taken from the quarterly newsletter of the IBBI. And yeah, let me move forward. I've as I said that this high 43% of cases involved therein prompted our governing body to have a session on this judgment immediately, and entrusted with the task of doing so. And I'm in front of you. Thanks in advance to all my audience, esteemed audience who present there, along with our honorable guest Shri J. Sharma ji and Mr. M.M. Kumar, who will be joining us very soon. Okay, let me delve deep into it. देखिए, हम इस पर्टिकुलर केस को बहुत डीप वे से एनालाइज करेंगे, तभी हमने अपना 1 घंटे का ये सेशन रखा है, so that we can understand all the intricacies of this particular case. और हमारे साथ शर्मा सर भी हैं जो हमारे को ultimately will enlighten us further. तो जो ये केस है इसके बारे में we be delving into a bit deep. तो सबसे पहले this case belongs to edutech known as Byju. Byju is still an Indian multinational edutech unicorn startup from Bangalore. It started its operation in 2011, hardly 13 years ago. And look at its valuation. Its peak valuation was 22 billion, meaning thereby 1.85 lakh crore. Yeah, it's a very, they were having a very, very huge valuation. और इनके पास जो registered students थे वो थे approximately 15 करोड़ के आसपास के. Highest in the whole world. You see the minimum size of their business. It was not only national but international also. It attracted large investments from global firms like Sukiya, Tencent, Mark Zuckerberg, Chinese Chan Zuckerberg, and also purchased many big companies in edu sector like Vista, Osma, Whitehead, Akash Institute, etc. Unfortunately, highly unfortunately, as present its value is zero. From 22 billion, it declined to zero within a span of 4 years only. And how it eroded so quickly, it's absolutely $1 million question. Please note, please note, yeah, one thing interesting I found there is that being the highest edutech application company, high-tech, edutech company, it made applications for almost all courses, including engineering, medical, accounts, and law also. But nothing was done for the IBC. Despite we have a very tough exam also, and we expect that sooner or later they will have some sort of application for the prospective RPs also. In any case, world is round. It's absolutely round. Byju ने हमारे लिए कुछ नहीं करा, but Byju came under IBC. It came to the IBC, go back out of the IBC, again came back to the IBC. It's all a the cyclic effect on this thing there. Another important aspect is that promoters raised rupees 150 crore from their own resources and paid via CD to BCCIC with the intention of going out of IBC. But at the same time, on this okay, with the intention of going out of the IBC, but at the end of the day, promoters' money of rupees 150 crore is the money of the COC now, along with accrued interest, and BCCI is simply sitting on as an OC. And we all know what the fate of OC is there under IBC 2016. In any case, we are able to understand deeply the intricacies of already known to us very important Section 12A, read with Regulation 20A, read with Regulation 30A. It has been thoroughly examined by our Honorable Supreme Court in their judgment dated 23rd October 2024. Basically, अगर आज आप 26 तारीख है तो 2 दिन पहले ही ये जजमेंट आई थी. The case name is Glass Trust Company LLC versus BYU's Ravindran and others, and appeal number was 9986 of 2024. Interestingly, Rule 11 of NCLT and NCLT has been thoroughly examined along with many other practices as has developed with the passage of time for the stakeholders and for the judiciary also. And if I talk in one say, they have put a break on the Rule 11 of NCLT, NCLT now, which they were using quite frequently. But one happy thing is there that we RP and IRPs are generally criticized by the higher authorities, one of the other reason. But in this case, remember, in this case, the powers given to us by the statute has been very well recognized, and it has been very clearly said that application of trial should have been routed through RP rather than by the applicant or by the promoter or like that only there. I would like to read, a very pertinent comment by the Honorable Supreme Court for the powers of NCLT and NCLT under Rule 11. Honorable Supreme Court said, the Honorable Supreme Court bench led by Chief Justice D.Y. Chandrachud, comprising Justice J.P. Pardiwala and Mr. Shri Honorable Justice Manoj Mishra ji, held that inherent powers can't be used to serve legal prisons, which exhaustively provide for a procedure to permit the enclave to circumvent the detailed procedure by invoking its inherent powers under Rule 11 would run contrary to the carefully crafted procedure for withdrawal. In this implicit judgment, the NCLT does not provide any reasons for deviating from this procedure or the urgency to approve the settlement without following the procedure. No, these are the words very, this is the absolutely picked up from the judgment. No full stop and comma added by me. So it itself speaks about that how hard Honorable Supreme Court has come on Rule 11 of NCLT, NCLT. As far as theoretically, it was a civil appeal number 9986 of 2024 with SLP number 21023 of 2024, decided on 23 October 2024. Now let's move to the facts of the case. Let's understand deeply the facts of the case so that we, when we analyze this particular judgment, we should be able to correlate it with our analysis. On 23rd December 2023, BCCIEC, the second respondent in this case, filed a petition under Section 9 of the IBC for an OC of operational data of 150 crores. Payable by Think and Learn Private Limited, CD. Think and Learn Private Limited is CD and Byju is a trade name. Under the team sponsorship agreement and so and so. NCLT admitted petition as on 16 July 2024. Or separately, parallel to that, Glass Trust Limited Company LLC, who is the appellant in this particular case, also filed a Section 7 petition against the CD as on 21st January 2024. Dates are very important. Take care of, have a look on this date. On 16 July 2024, NCLT disposed of the Section 7 petition in view of the order passed on the same day, admitting the Section 9 petition filed by the BCCI. The appellant was granted liberty to file their claim before the IRP appointed pursuant to Section 9 order. Section 9 जो BCCI के गेस था, जो BCCI ने फाइल करा था. The IRP made a public announcement as on 7 July 2024, and appellant filed its claim subsequently, within 7-8 days as on 25th. Both the appellant and the first respondent moved to the NCLT in appeal against the respective orders of the NCLT. What the NCLT did on the next day of the hearing, when they filed the petition, immediately on the next day of the hearing, NCLT. It was recorded that the parties arrived at a settlement and payment was perpetually made pursuant to a settlement offer extended by the Byju. Ravindran, in his original capacity to the second respondent by an email dated so and so, he proposed to clear the operational data 158 crores in 3 tranches of 30 July, 2 August, 9 August respectively. The second respondent agreed to take steps for withdrawal of the petition upon receipt of the full payment of the OC. It's quite natural. BCCI got the money and they, went into, they said, we withdraw application. On 31st July 2024, when the parties sought to place a settlement on record before NCLAT, although CIRP had been initiated and an IRP had been appointed, the COC had not been constituted. Important part is COC at that particular time was not constituted. On 2nd of August, through relevant order, reported in Mr. Byju versus the Thin and CD, the NCLAT held the affidavit and undertook filed by the Byju's promoter director, Ravindran made that money was generated by his own sources, and there's no round tripping of CD to him and then to a creditor like that, and there's no nothing like that there, and accordingly NCLAT accepted this thing and went there. There was also one main point also, a parallel proceedings are going on in Delaware court also for recovery of the money abroad. And NCLAT also held that there is no violation of Delaware court also. Therefore, NCLT held that in the absence of any evidence to the contrary, there was no reason to believe that the money that was being offered by promoter director was linked to the money distributed by Byju Alpha Incorporation under the credit agreement or from the coffers of the CD. Further, it was held that the law regarding the settlement of disputes between the parties is in the process of evolution. Court even at that time also took cognizance of the fact that this particular law is in the process of evolution. And in any case, the court, despite all this thing, approved this particular settlement by invoking the inherent power given to them under Rule 11. They placed reliance on two cases. One was of Abhishek Singh and Hatomaki PPL Limited, and another was Kamal K Singh and Dinesh Gupta. तो ये मैं जो आपको बात कर रहा हूँ तो ये मैं सारी की सारी आपके साथ share कर लूँगा so that you can have a look on it also and can use in your proceedings also. Accordingly, the settlement between the parties was approved and the order of the NCLT admitting of the Section 9 petition was set aside. Okay. Insolvency process after institution of this appeal. The appellant instituted the present civil appeal challenging the relevant judgment of the NCLT. The Honorable Supreme Court, White Order dated 14th of August 2024, stayed the operation of the impugned judgment and the CIRP proceedings resumed. The IRP constituted the COC and the first meeting of the COC took place on 3 September 2024. On 26/9/2024, the Honorable Court observed the judgment and directed that the IRP maintain the status quo and not held any meeting of the COC until the judgment is pronounced. पहले उन्होंने CIRP प्रोसेस को वो कम करा और उसके बाद उन्होंने उसको स्टेटस को कर दिया. Question, what pertinent question rises out of that? Whether the appellant, who is not a party to the settlement between the second respondent and the corporate debtor, has locus stantис in proceedings before this court. You try to see there कि केस जो इनिशियली था वो सेक्शन 9 और उसकी जो एप्लीकेशन थी सेक्शन 7 की एप्लीकेशन थी, इट वाज बिटवीन सम अदर्स. अब यहाँ पे जो एप्लेंट है ही इज सम अदर पर्सन. तो another question was that whether the NCLAT erred in invoking its inherent power under Rule 11 of the NCLAT Rules 2016 in the presence of the prescribed procedure for withdrawal of CIRP and settlement of claims between parties, and without prejudice to the above, whether the NCLAT adequately addressed the objections raised by the appellant while exercising its discretionary power under Rule 11 or not. Basically 3 pertinent questions were raised therein, which I have just talked to you कि जो settlement था वो proper था नहीं था. Number 2, Rule 11 को NCLAT ने for the whole benefit of IBC use करा नहीं करा. और तीसरा कि whether this ये जो outside party है इसको objection raise करने का right है या नहीं है. Honorable Supreme Court held, it talked about the general principles underlying the IBC. Firstly, the objectives discernible from the long title and the settlement of objects and the reasons of the IBC was discussed in the decision, in the decision of 2 benches in the famous Swiss ribbon case. The Honorable Court observed that the IBC is a beneficial legislation which attempts to put the CD back into its feet. According to this court, This would evolve considering the interest of all the concerned stakeholders rather than viewing the IBC as a mere recovery legislation for individual creditors. They have pronounced this thing in page 37. What they mean to say is that कि जो भी बीसीसीआई ने सेटलमेंट करी, उसके बाद जब ये केस कोर्ट के अंदर आ गया, ये एनसीएलटी के पास आ गया, तो एट दैट टाइम adjudicating authority or the appellant adjudicating authority should have taken care and interest of all the creditors rather than of a one person. अगर एक बंदे का उन्होंने करा तो meaning thereby कि that is not correct as far as law is concerned, because IBC is not a recovery platform. They have the occasion to discuss their 2 points on their earlier judgments of Arun Kumar Jagtamaka versus Jindal Steel and Power Limited. इस चीज से उन्होंने reference लिया. And what guiding principle emerged out of that? A significant change, what the guiding principle was that a significant change brought about by the IBC was the consolidation of pre-existing fragmenting insolvency network. The aim was to eliminate parallel proceedings by various creditors before different for or a given debt creditors would be a part of a single insolvency process under the IBC. The above consideration also sought to be implemented the principles of collective distribution, where the interest of all stakeholders were considered. The CIRP envisaged by the IBC is premised on the principles that each creditor of the same class would receive a share that is a proportion to debt out to him. IBC must not be used as a tool of coercion and debt recovery by individual creditors. Here, individual creditors was BCCI. Improper use of the IBC mechanism by a creditor includes using insolvency as a substitute of debt enforcement or attempting to obtain professional payments by coercing the debtor using insolvency proceedings. That the mechanism under the IBC must not be used as a money recovery mechanism that has been reiterated again and again by the court. The interests of the corporate debtor must be detached from those of its promoters who are in management. A recalibration management must be prevented and from taking the advantage of undue delays and preventing in an inevitable insolvency. In other words, as was noted by the court, as I mentioned in earlier case, Arun Kumar, Jagtamaka, etc., etc. In any case, this thing was noted by, at page 39. No, now let's make a distinction of personam in rem and personam in personam and in personam in rem. Nature of the proceedings after revision of the application proceedings are personam or in rem. मीनिंग देयर बाय कि जब तक तो एप्लीकेशन फाइल नहीं हुई तब तक तो एक क्रेडिटर और डेटर कह लो, जो एट द मोस्ट मैनेजमेंट कह लो, वो इन्वॉल्व होती है. बट वंस एप्लीकेशन हैज बीन एडमिटेड, देन that particular is concerned, then IBC is concerned with all the persons involved therein, especially जिन लोगों ने अपना claim file करा. During that process, they elucidated section 5 subsection 11, which defines initiating date, section 5 subsection 12, which defines insolvency commencement date. Okay, now come to what they concluded. Therefore, the proceedings now change character. After admission, the proceedings change character. They become in remand, are no longer the presence of only the applicant creditor and the corporate debtor, and even the creditors who are not the original applicant become necessarily stakeholders also. So, what I said is that if we divide our application into 2 parts, before admission and after admission, all stakeholders get involved there. This was held by the Honorable Supreme Court, and the same thing they held earlier also. They have referred the case of Indus Biotech Private Limited versus Kotak India Venture Offshore Fund also, where they have the same thing. In summary, the scheme of IBC under Chapter 2 gives rise to 2 significant principles. Once that petition is admitted, the proceedings are no longer the preserve of the applicant creditor and the debtor. They now become in rem, and all creditors of the corporate debtor become stakeholders in the process. And once the petition is admitted, the management of the, another important aspect which they noted down is that once the petition is admitted, the management of the affairs of the corporate debtor is vested in the IRP and eventually to the RP. Thus, the CD no longer exists in the form that it did before the admission of the petition. Once CIRP is initiated, the interest of the erstwhile management of the corporate debtor must be distinguished from the interest of the corporate debtor. कहने का मतलब यह है कि एडमिशन के बाद ये IRP RP हो गया, ही इज द मैनेजमेंट, एंड COC जो है दे आर द बोर्ड ऑफ डायरेक्टर्स. और जो पुरानी वाली मैनेजमेंट है, जब पुरानी वाले बोर्ड है, दे हैव अ वेरी लिमिटेड रोल आफ्टर एडमिशन. This thing is very important. Why this is very important? I'll let you know when I talk about my coming paragraph. Legal framework for withdrawal and settlement of claims. तो अब उन्होंने ऑनरेबल कोर्ट ने डिस्कस करा आफ्टर पेज 50 कि व्हाट इज द लीगल फ्रेमवर्क ऑफ विड्रॉल एंड सेटलमेंट ऑफ क्लेम्स देयर. Till amendment in CIRP regulation 30A, accepting the recommendation of the ILC Insolvency Law Committee, the legislator introduced section 12A in the IBC by Second Amendment Act 2018 with effect from 6 June 2018. इससे पहले जो था, I just tell you, we people are the old practitioner. तो इससे पहले withdrawal का कोई concept था ही नहीं. So this they have referred in page 51. Significantly, the text of trial only details the procedure for the withdrawal of the application after the formation of the COC with 90% of voting share, but is silent about the withdrawal of the application after the application is admitted, but before COC is formed. They have referred it on the page 52. Meaning thereby कि even after amendment जो है 12A और the read with regulation 30A, ये अभी भी ये बताता है कि आप कब withdraw कर सकते हो. It takes on the situation when COC is formed. COC जब तक अगर फॉर्म नहीं हुई तब तक क्या सिचुएशन है, उसके ऊपर एक्ट अभी तक साइलेंट है. Notably, into section 12A, regulation 30A in its original form, was silent about withdrawal in cases where the application had been admitted but the COC had not been formed. Similarly, sub-regulation 1 of regulation 30A only spoke of withdrawal before the invitation of expression of interest had been issued, and there was no provision which provided for withdrawal after it had been issued. Both these gaps were identified in subsequent judgments of the Honorable Supreme Court, meaning thereby in Brilliant Law Private Limited versus S. Rajagopal, and definitely in Swiss Ribbons also. In nutshell, they said, however, given the in rem nature of the proceeding, such an application must be decided only after hearing from all the parties concerned and considering the relevant factors of the case. This they adjudicated. This high threshold of 90% voting share of the COC is not arbitrary. The idea is that the financial creditors have to put their heads together to allow such withdrawal, and under section 60 of the IBC, the decision of the COC to reject or accept the settlement claim can be challenged before NCLT, and then NCLT, can look into the adjudication of NCLT. Now let's talk about after amendment of CIRP regulation 30A, which was with effect from 25th of July 2019. In response to the lacuna identified by the creditor in Swiss Ribbon case, as an amendment was made under the regulation 30A. This amendment came into effect on 25 July 2019. Page 59 पे इन्होंने डिटेल में लिखा हुआ है. Regulation 30A1 now provides for the procedure to make an application for withdrawal before the NCLT under section 12A, both before and after the constitution of the COC. They've written it in page 60. The provision to section 30A1 now provides that when the application is made after COC has been constituted and after the invitation for expression of interest has been issued, the applicant shall state the reasons for withdrawal at this stage. In absence of the regulation, important word is state the reason for withdrawal when this expression of interest has been issued. In a sense, the regulation in its amendment form deviates from its earlier form by also responding to the decision of the court in Brilliant Law Private Limited case, and so on and so on. Unlike the unamended regulation, the regulation acknowledges the possibility of withdrawal even after the invitation of expression has been issued. However, it mandates that an application for withdrawal in such cases must be accompanied by reason. What the difference between withdrawal before issue of expression of interest and after issue of expression of interest. In the case of issue of after expression of interest, it should be accompanied by the reason that is there. No, cumulative everything together. Accumulating everything together. Now they have come out with the 4 stages. What are those 4 stages? They 12A की उन्होंने 4 stages को define कर दिया. What are those 4 stages? These are, in a sense, after a series of deliberations of the legislature, the executives and nudges of this court, the framework created by Rule 8 of the NCLT rules and Section 12A of the IBC, read with Regulation 30A, read with Regulation 30 of the CIRP regulation, lays down an exhaustive procedure for the withdrawal of an application filed by creditors under Section 7, 9, and 10 of the IBC. Withdrawal may be sought at 4 stages, all of which have a procedure prescribed under the existing framework. These are summarized as follows. क्या वो 4 steps हैं जिस stages के 4 stages हैं जिनके अंदर withdrawal कर सकते हैं और उनके अंदर क्या procedural aspects हैं. Let's understand that thing there. Before the application under Section 7, 9, and 10 is admitted by the NCLT, such cases are squarely covered by Rule 8 of the NCLT rules, which requires that the applicant approach the NCLT directly. The NCLT may then pass an order permitting the withdrawal of the application. In this case stage, as the CIRP process has not been initiated, the proceedings are still in person as between the applicant creditor and the corporate debtor. Therefore, while approving the withdrawal at this stage, NCLT may restrict its inquiry to only hear the applicant creditor and corporate debtor, and other potential creditors are not stakeholders at this stage. I repeat again, important thing is applicant creditor, corporate debtor, and no other. Okay, now let's come to the stage number 2. After an application under Section 7, 9, 10 is admitted, but before COC has been constituted. Although Section 12A continues to be the silent on this aspect, but after the decision of Swiss Ribbon, Regulation 30A was amended to provide for this eventuality. An application for withdrawal in such cases may be made by the applicant through IRP. I emphasize my word on IRP, through IRP. Existing practice is that जिसने withdrawal करनी होती है खुद ही अपनी application बना के भेज देता है. But in my practical life, I'm also under thief for withdrawal. I always make sure that this withdrawal application is made through IRP. RP generally तब तक पैदा ही नहीं होता. The IRP will then place the application before the NCLT, which may pass an order either approving or rejecting the application. As noted above, once the application has been admitted, the proceedings are no longer the sole preserve of the applicant, creditor, and CD. They are now in rem. And at this stage, NCLT must hear the concerned parties and consider all relevant factors before approving or rejecting the application for withdrawal. The NCLT, being a quasi-judicial body, must not act as a mere post office, which stamps and approves every settlement agreement without application of judicial mind. In any case, now let's move to the stage 3. After an application under the Section 7, 9, and 10 is admitted, the COC has been constituted and the invitation for expression of interest has been issued in Form G. In that case, Section 12A, read with Regulation 30A, provides exhaustively for the same. In such cases, the application for withdrawals to be placed before the NCLT, though the IRP or the RP, through the IRP or RP, the application is first placed before COC. And after certain approval from 90% voting shares, the RP shall submit the application to the NCLT. Okay, in that case, they say that before issue of the expression interest, only requirement is that COC 90% के साथ इसको pass करते. After an application under Section 7, 9, and 10 is admitted, the COC has been formed and the invitation for EOI has been issued. The procedure is the same as that detailed in para 3 above, with the added requirement of reason of withdrawal in that belated stage is to be given. These are the 4 stages. और इस 4 stages में क्या-क्या हमारे को steps लेने हैं या क्या-क्या हमारे advocate brothers को step लेने हैं for withdrawal under Section 12A, Regulation 30, Regulation 30A के अंदर. So that has been there, noted there. Now let's see. Now along with this 12A, 30A के साथ एक और important aspect Honorable Supreme Court ने deal करा, that is of the Rule 11. We all know Rule 11 of NCLT rules or NCLT rules gives them enough power to do anything. I should not say do anything after this particular judgment, to do the things what they feel is appropriate under the given circumstances. They have touched upon the Article 142 also in this case. Comprehensive framework to deal with withdrawal and settlement, Rule 11 of NCLT rules and so, or even the powers under Article 142 no longer arises. Article 142, as we know, gives ample power to Supreme Court to override any act in public interest and give decision. Not only is there a exhaustive framework to deal with withdrawal and settlement, but the evolution of the law and the creation of an comprehensive framework indicate an attempt to reduce reliance on discrepancy and all this in there. Withdrawal application, now I'll be moving a bit quickly because time is already, I've taken so much time. Withdrawal application under Section 12A should be only through IRP. NCLT conducts an adjudicatory exercise and the procedure is not mere technicality. Another point they have, I have written, which there's a lot of things on it, but due to paucity of time, I'm just passing through. Inherent powers under Rule 11 of NCLT and NCLT rules is limited to the extent whereas there is nothing specifically defined under the code or regulation. If anything is defined under code and regulation, then NCLT, NCLT can't adjudicate those matters by exercising power under Rule 11. Honorable Supreme Court, while interpreting Rule 11, PAR has come out with, some, they noted down some decision in their page 83 also. One is Kamal K. Singh and Dinesh Gupta. ये मैं आपको share कर दूँगा तो ले लेना. Shok Ji Gujranani and Abhishek Singh and this is there. Okay, one more aspect they have, clarified in this particular judgment. Actually, what happened कि in this case, जो NCLT या NCLT के against कोई third party गई थी. So whether they have adjudicated that under Section 61 or Section 62 of the IBC. Can any other person, aggrieved by a particular order of the NCLT or NCLT can come to the Honorable Supreme Court or not? Honorable Supreme Court has held. The words used therein is the phrase used in this particular section 61 is any person aggrieved, meaning thereby कि सिर्फ applicant और defendant ही नहीं, कोई भी बंदा अगर किसी NCLT के order से aggrieved है तो they can come to the court for all these purposes. So with this my saying and my enlightenment जो भी थी that it has reached to the end now. Now I open up the Pandora box for for everybody to deliberate on this particular judgment, and I would request our honorable NCLT member, Honorable and Mr. Nilesh Sharma, to take the baton from me and start deliberating. And wherever we have the question, we shall answer collectively to all the audience. Or even before that, I would say I would request our honorable guest of honor to add what I have heard or what I have missed, or because naturally we are insolvency profession, we know how to run the company, but as far as legal aspects are concerned, sir knows far better than us. Sir, please welcome and start your deliberation.
Thank you, Mr. Anand. I was listening to you with a lot of attention, and I have gone through the judgment of Honorable Supreme Court in this case. I could not find even a single word or sentence in the Honorable Supreme Court decision which is not written in the law. It is 12A and 30A. 12A section and 30A regulation of CIRP. Supreme Court has just enlightened us that, dear sirs and madams, what is written is there. Please follow it, nothing else. Tell me even a single word which Honorable Supreme Court has added in the law, or for that matter, they have said that this is what whatever is the written law, they have just they have just reiterated that and said that please follow it, what is written there, nothing more than that. 30A, there is a clear-cut procedure which has been laid in the CIRP regulation. that what is to be done at what stage, what is to be done. IRP is to be, involved in every matter. The form FA is to be filed with IRP. IRP will file an IA. Everything is written there. The basic problem which we were facing is that we were not following 12A and Regulation 30A religiously in all our proceedings. It is convenient for everybody not to follow the law. Tell us when the suspended management is interested in settling with the creditor concerned. He used to come either at NCLT level or NCLT level, and we have been conveniently passing the orders for closure of the CIRP if it is before COC formation. If it is after COC formation, of course, 90% of the voting right has to be exercised in favor of the settlement. Honorable NCLT has been, it is for the convenience also, because there is no point when the settlement is being brought before NCLT, and NCLT says, go back to NCLT and settle your case there, file your Form FA there, and let the RP deal with it. And let me tell you, whatever has been practiced till now, it is not only at NCLT level. Honorable Supreme Court has also been passing the orders, confirming the NCLT orders of settlement. Now, they have provided full clarity on this issue, and they have made the procedure to be practiced by all the practitioners, including the benches at NCLT and NCLT. This is what my take on this judgment is. Nothing more than that.
तो बेसिकली कहने का मतलब ये था कि जैसे हम अपनी सीए की प्रैक्टिस में या आईपी की प्रैक्टिस में शॉर्टकट यूज करते हैं काम करने के लिए, सिमिलरली लॉ अथॉरिटीज और एडजुडिकेटिंग अथॉरिटीज हैज आल्सो बीन यूजिंग दिस थिंग देयर, बिकॉज उनको अल्टीमेटली लगता है कि देखो केस सेटल हो रहा है ना, होने दो, इसके अंदर कोई थोड़ी बहुत ही प्रोसीजर इरेगुलरिटीज है भी है तो लेट दैट बी देयर। लेकिन सर इसके अंदर एक बात जो, जैसे इस पर्टिकुलर केस के अंदर एक बात आ गई, हेयर व्हाट हैपेंड कि बीसीसीआई ने जो एक बात है सीक्रेटली या अदरवाइज अपना सेटलमेंट कर लिया, बट एट द सेम टाइम जो फाइनेंशियल क्राइटेरिया था, जो यूएसए की कंपनी थी, तो वो उसके पैसे जो थे वो दाएं बाएं हो गए, जब उसको लगा कि मेरे पैसे तो मैंने एप्लीकेशन भी फाइल करी जिसको इस करके डिसमिस कर दिया गया कि वो सेक्शन 9 की एप्लीकेशन थी, सम सॉर्ट ऑफ यस प्लीज कमेंट ऑन दैट सर।
ना उसका कोई पैसा दाएं बाएं हुआ है, ना उसका कोई पैसा 1 रुपया भी यूटिलाइज हुआ है बीसीसीआई के साथ सेटलमेंट में। That money has been, there are two brothers, one is Byju, one is Riju. Byju Ravindran and Riju Ravindran. Byju Ravindran was managing this company. Riju Ravindran was earlier there. Now he is not as director in the company. He brought this money and settled with IBC. You see, there is nothing peculiar about it. Every third day, every settlement is being done like this only at NCLT level and NCLT level. Only thing is that in this particular case, the issue went up to Supreme Court, and there are some points of law which have been raised in the same fashion, the way Supreme Court has given in its judgment. They said that 30A has to be followed in letter and spirit, and every possibility has been given in 30A. Why are you circumventing 30A and straight away using your Rule 11 powers? Honorable Supreme Court has specifically said that for that matter, R142 is much enlarged at Rule 11. Rule 11 is you can follow in only IBC. 142 can be followed by Honorable Supreme Court in any matter where the law is not clear. They said, please restrict your Rule 11 power the way we are restricting our 142 power. They have not written it, but the message was this only. And wherever the law is clearly providing through a section in the law or through rules or regulation, here to be specific, regulation 30A, then please follow that, what has been written. And for that practical purpose, for 12A and 30A, Supreme Court has at present put a lock on using Rule 11 powers for NCLT and NCLT. This is what it is.
No, sir. Actually, most probably I was not able to convey my question properly. मेरे कहने का मतलब ये था कि जो देखिए एक क्लास ट्रस्ट LLC ने जो एक सेक्शन 7 की एप्लीकेशन फाइल करी थी, उनकी एप्लीकेशन जो थी वो डिस्पोज ऑफ कर दी गई इस करके कि आप अपना क्लेम फाइल कर दीजिए और अल्टीमेटली सेक्शन 9 की एप्लीकेशन हो गई। मैं उस पैसे के बारे में बात कर रहा था, मैं इस पैसे के बारे में बात नहीं कर रहा। सर देखो, ये जो 158 कोड है, ये तो मैंने पहले ही कहा, ये तो ना वो हुआ, ये प्रमोटर ने किसी भी तरह से बेचारे ने इकट्ठा करके दे दिया होगा सेटलमेंट करने की, और वो पैसा जो था प्रमोटर के हाथ से निकल के और COC का बन गया।
Mr. Anand,
Yeah.
you yourself and all the people who are here connected, all are
Yes,
IP,
sir.
IPs
Yes,
there.
sir. Yes, sir. Yes, sir.
You see, every third day you must have been using the same thing, doing the same way the settlements. You know, the person whose application the money has, this case has been admitted,
हाँ जी
you
सर।
have to settle with him only till the time COC is not constituted. After COC, of course, 90% voting right is there. Without that, you cannot do any settlement.
हाँ जी, हाँ जी, हाँ जी, हाँ जी, हाँ जी।
In this particular case, you know the beauty in this particular case.
Yes, sir. Yes, sir. Enlighten us. Enlighten us.
Glass Trust is not a financial creditor of this company. They have given the credits or facilities for US subsidiary of this think and tank.
Okay. Think tank.
Think and Learn Private Limited.
हाँ जी।
Its US subsidiary has been given few facilities by Glass Trust. However, Think and Learn Private Limited has given a corporate guarantee for the US company credits. As a matter of fact, in this case, the COC is constituted only one creditor who is having rupees 20 crore outstanding.
Okay.
Glass Trust is not a financial creditor in this case as yet.
Okay.
The concerned RP has kept them as a contingent liability, which they are fighting, which they were trying to fight with in Honorable Supreme Court, and Supreme Court has practically not given anything to Glass Trust. They said, we are not sitting here as adjudicating authority for adjudicating your claim. Your claim is having so many dimensions. It is Delaware court proceedings or other things. So many things are there. We can't adjudicate here. You have to go to NCLT for adjudication of your claim. But RP has kept it as a contingent liability, not even constituted liability. And he has not brought them to COC. COC is only one creditor who is having 20 crore rupees outstanding. And if Byju has done 158 crore settlement, he can jolly well do 20 crore rupees settlement also.
Yes,
now,
yes,
NCLT has to hear. One thing more I would like to clarify here. NCLT has given full time to Glass Trust, who filed an appeal there. They were heard fully before passing this order by NCLT. And there is nothing new which has been done by NCLT here. This has been done every second day by NCLT in almost all the cases where settlement is directly coming to NCLT. That is good. Now all those things have been set to rest, and now NCLT has to deal with all settlement proposals, whether it is before admission, post-admission, before constitution of COC, and post-constitution of COC, in both the cases where EOA has been filed, expression of interest has been published or not. So now NCLT has been given this whole responsibility to deal with settlement.
In any case, I was feeling happy that it's a basically reading of the lines. आपने कैसे पढ़ा, मैंने कैसे पढ़ा, मैंने इस तरह से पढ़ा इसको कि जैसे ये कहा गया है कि जो प्रोसीजर दिया हुआ है फॉर्म एफए का वो यानी कि कहने का मतलब ये था इन नटशेल कि जो भी सेटलमेंट की एप्लीकेशन है इट शुड डेफिनेटली बी रूटेड थ्रू आरपी ओनली rather than people acting independently. I was happy with that कि चलिए कहीं ना कहीं तो हमारी आरपी की आईपी की पावर्स को थोड़ा सा ऑनरेबल सुप्रीम कोर्ट ने हाईलाइट करा
But there is a word of caution for RPs.
यस सर, बताइए ना, बताइए प्लीज.
No, the word of caution is the moment Form FA is submitted to you by the concerned creditor and the company duly settlement agreement with you, you are to file it with NCLT as per rules within 3 days. And you cannot delay it further. You cannot keep it in your pocket and say, do this, do that, this, that, and then I'll file it. Till that time, your concern is up to your fee only. And that has been very well taken care of in 30A2B, where a bank guarantee is to be provided for your fee. If your fee is already settled, then there is no question of even holding for that also. When I took over at Mumbai NCLT bench,
yes sir, this
30A2B came just about 25 days after that. It was new for everybody. So in a series of cases, and let me tell you, not even a single case during my tenure in NCLT where we used powers under Rule 11 rather than 30A2B. We were following 12A and 30A2B in its letter and spirit in all the cases, and only one exception we did, that where the money has already been paid to RP towards his fee, and he confirms to us that yes, dues, whatever I have incurred and whatever my fee was. In that case, we just dropped that bank guarantee condition because the money has already been paid to RP. Nothing, no deviation accepted.
In fact,
सर मैं ये कहूंगा सब लोगों को प्लीज अपने, अब इंटरेक्शन हो रही है, इनफैक्ट आई शुड हैव सेड अर्लियर, प्लीज सब लोग अपने वीडियोस ऑन कर लीजिए, और नीलेश जी नाउ यू टेक द बैटल फ्रॉम मी एंड हैव फर्दर डिस्कशंस.
Yes. So Rajesh,
everybody on their video please.
Yeah. So Rajesh, one question. I think another important issue has been decided by Honorable Supreme Court in this particular matter, and that issue is relating to locus of this party to file an appeal. I'm talking about Glass Trust Company, LLC. So I think that was another important thing which has been said by Honorable Supreme Court. I request you to kindly enlighten us about the reason which has been given by Honorable Supreme Court relating to this.
With respect to the party which is not a party to this. Yes.
Which is not party. Section 60, Section 61.
Yes.
61 and 60.
It's very clear on this issue. Honorable Supreme Court has very clearly said that the word written there is any party.
Aggrieved.
Any person aggrieved of the decision. Correct. He may or may not be a creditor even.
Correct. So it may not be a party to that order, but still, if it is aggrieved by that order, so that party can file.
That is also coming from the bottom of this particular IBC code.
Correct.
The proceedings after admission of the case into insolvency, the proceedings are in rem. These are not proceedings in personam.
Correct.
Before that, before admission, these are proceedings in personam.
Right, Rajesh.
Personam proceedings are between A and B.
Yes.
Proceedings in rem are any person who is not connected with the company can come and say that I have this objection, and NCLT has to deal with that objection. And you see what best they can do. They can dismiss it, but they have to hear him and dismiss.
Definitely.
Not say that you have no concern with this. Go back. You can't say that.
Right. Thank you, Rajesh. Thank you very much.
I would suggest that the audience, the participants can ask the question.
Yes. So if
Yeah,
you
I
have any
request
time,
Mr. Anupam Lahiri to have a few words. He is from, from ex-NCLT principal bench. तो इनका भी एक अपना ही यूनिक सा एक्सपीरियंस होता है. अनुपम जी, प्लीज शेयर योर थॉट्स. अनम्यूट कर लीजिए अपने आप को.
Mr. Lahiri.
Yeah. Yeah.
Good evening. Good evening to all.
Good evening.
Regarding this judgment, the day when it was passed, that day, Sharma sir had posted in the LinkedIn, and in the very same day, in the evening, I downloaded it and I had read the judgment. Side by side, I am reading the NCLT and NCLT judgments also, which is one of my method of studying one judgment. Now, point is that what we have seen, it is a very good exposition of the law on withdrawal of application. But one thing is that as a matter of fact, in NCLT also, the procedure should change. Like at present, if we ask how many applications are pending against one corporate debtor, there is no statistics, because I had done it for 3 years, but that I have failed. But at this point of time, possibly this type of statistics also should be maintained, that how many have been filed, out of which how many have been withdrawn. Because from my experience, I have seen, though we are telling that these many applications have been withdrawn, but what is the effect? Many applications have been withdrawn before admission, but again it has been revived after some time. That is why the caseload has become quite high. That is my preliminary observation. Thank you.
Thank you, Lahiri ji. Any other question? Mr. GP Madan is also there. I request Mr. Madan to share his views with respect to this particular judgment. Mr. Madan, Mr. GP Madan. GPG. Any other question? Okay, then I think.
You see, I would like to contribute something here.
Yes,
I will not name the corporate debtor because it is an existing company doing very well. And but I can share the contents of the case.
Yes, please. Yes, please.
A very big company having an outstanding of more than rupees 10,000 crores. It was admitted into insolvency by us for a meager sum of about 10 crore or so. They came with the settlement, but by that time, the claims were filed for about 6,500 crore or so. COC was not constituted, but the claims came of about 6,500 crore or so. They came for settlement, taking a wholesome view that, of course, 600,000. Again, same thing. What this drill was done in Honorable Supreme Court in this case. The same drill was done by us in that case in NCLT Mumbai, and we did not allow the settlement for some time. But somehow they had their fate. There was a vacational bench which allowed this settlement, and somehow the end company is now running very well. There is no issue about it. So, most of the time you will find that when we try to bypass the things, then the problem creates. In case you follow the law, what has been written, what is the practice, what is the precedent, I don't think much problem is coming in your way. Let me tell you, in the entire period when I was sitting in the benches, I did not find this type of problems that you should do this, you should do that. Our mind was very clear that this is to be done, this is not to be done. That's all. So one has to be clear in his mind.
Definitely. So I think with this we can close our session because there are no further questions. But before that, let me summarize what Rajesh ji has told us about this judgment. So two important questions were there which have been decided. One is relating to the locus of this particular party. So this party, which is Glass Trust Company LLP. So because even if it is a party, even if it is not a party to the original proceedings which are appealed against, still, if they are aggrieved by the order passed by NCLT, they can still file an appeal under Section 61 and Section 62. So this is one of the important important ratio of this particular judgment. And second important thing is that Rule 11 cannot be applied when express provisions are there under law. Okay, so in this particular case, Honorable NCLAT invoked the provisions of Rule 11, but Honorable Supreme Court says when we are already having specific provisions under Section 12A and Regulation 30A, then the invocation of Rule 11 was not justified. So these were two important things. And I think with this, we can close today's session. I request Manoj ji, vote of thanks.
Thank you very much. Thanks a lot. And, we are quite affectionated with the esteemed presence of people, especially our CA brothers, despite, having a last day on this thing there. And to Sharma ji also, Jay Sharma ji also, जिनको मैंने आज सुबह ही रिक्वेस्ट करी और उन्होंने मेरी रिक्वेस्ट को अपने बिजी टाइम में से निकालते हुए सीट करा. Thanks a lot. Thank you, Mr. Larry. Thank you, Mr. Udit Mukherjee, Uday Singh ji, who are our regular, attendant there. Mr. Kamal Arora was having, a long question on chat box. If he feels he can come over and ask the question, because reading that much long question was a little bit difficult for us. Mr. Kamal Arora, if you want, you can come forward, or otherwise we just close down the meeting. Thanks a lot. Happy Diwali to everybody. Happy Diwali.
थैंक यू राजेश जी. आपको दोबारा आगे फिर हम लोग कोई भी नया कोई जजमेंट आता है तो वी विल रिक्वेस्ट कि हमें उसको इंटरप्रिटेशन के बारे में गाइड करें. थैंक यू वेरी मच राजेश जी once again and everyone who has attended today's.
Thank you everybody. Thank you everybody.
Thank you all. Happy Diwali.
I'm closing the meeting,
Very
please.
happy
Thank
Diwali.
you. Happy Diwali to everybody.